on the back of it, of the record. It's a nice little paragraph. Office County Council informs everybody that we do not stipulate that any commissioner or referee sit as a judge pro tem. Mr. Trendacosta, with all due respect, you may not refer to yourself as a judge pro tem, because a judge pro tem is created by one, perhaps there are local rules and other rules, there are also just California rules of court, that, allow a judge to, appoint a certain attorney even to sit as a judge pro tem, but that's only part one. Unless the parties in the courtroom, and that means parents' council, minors' council, de facto parents' council, county council, stipulate that Mr. Trendacosta sit as a judge pro tem, he's not one. So make sure he doesn't call himself that anymore. And make sure you call your bench officer by the right name. Start calling referees. Of course, you've got a lot of judges down here now. So that's changing, but you're getting the referees back. Do not refer to Commissioner Steph Padilla as Commissioner Padilla. She is referee Padilla for purposes of these proceedings. Yes, Tim?
Since we're on this, when Ms. Castro stopped being a law firm director and went on the bench, they precluded her from being in dependency for 2 years.
Right.
For some judicial
Sanitizing, right.
Does that apply to Terry Trump?
Well, I certainly would be, if I were here, down here, I would be, every time I walked into the courtroom and saw referee Trong there, I'd say, whoa, I want to, a recess here, pretend to, make a record here. Referee Trong has moved from this position to this position. I want to make sure, voir dire, for example, that we do not have any conflict here. This is a sibling case. Earlier petitions, make sure the referee has had no contact with this case, or either as a former bench officer or in county counsel's office. You gotta make them, make people think about this, because it's obviously ripe for conflict. Right? Right. You have a drink of water? Just a little glass of water. Thank you. So, so we're gonna move forward here on to another topic. So nobody is ever gonna not object again. In fact, if when in doubt, just say object. and if the court says object to what, counsel? I don't know. I'm going to come up with it in just a minute here, but just give me a second. Object. Right? Okay. All right. So at least we'll have something. I don't know. Actually, the evidence code does require specific objections, so don't take that too serious. But I mean, at least stall for time. Object. Just that'll give you the opportunity for your brain to kick in. Oh God, yes. It's a phenomenal. It's a legal minefield out there. It really is. There's so much to be aware of in law. Thank you very much. And it's scary. I'm always looking for something that's going to bite me, and inevitably I'm bitten. You think you guys are bitten? Anyway, so all right. So let's just briefly another issue that is probably still out there is the press and public access to dependency proceedings. Of course, you're all aware of Judge Nash's blanket order that was the subject of the published opinion in Arlen L. Don't worry, this is written down here. Of course, you're probably all aware that since the published opinion in Arlen L., in which the Supreme Court denied review, there was a dissent. There was a dissent. That means this is far from, although the dissent is on procedural grounds, which I'll speak about in a minute. But anyway, after the opinion published in Arlen, Judge Nash issued a new blanket order. Right? Everybody's aware there's a new blanket order out there. Well, we need to compare the new blanket order to the opinion and see whether there's compliance between the new blanket order and the opinion. Near as I can tell, I mean, they're very the original blanket order and the new blanket order are very similar. Near as I can figure, Judge Nash's opinion is that there are 3 ways the public or the press, and I'm just gonna leave the public out of it and just say press, can gain entrance to the courtroom. Request of parents' counsel, and with the consent of the minor. Request of the minor, okay, or at the discretion of the juvenile court. And that's the prong that Judge, thank you, the water here, he's swimming. The Judge Nash is relying on. And I think he's got a legal point. He's got a legal point, so this isn't over with. But, you know, we did the Arlen L. case by appeal. I've got to really urge you to, as the writ attorneys, to consider seriously pursuing this issue by writ, and for the reasons set forth in the dissent by Justice Bigelow. You know, basically, you know, really the whole thing is, guys, you know, the press ultimately didn't even show up for the hearing to which they were granted access, and so the you know, one of the three justices had some very, you know, big concerns about, oh, this isn't even appealable here. You know, what are we talking about? So that's a real red flag if you know, if we're still looking at challenging, you know, the new blanket order. You got to watch out for those headlights and say, whoa, you know, we certainly don't want to be bounced out of court because we've chosen the wrong avenue of review. And I think, you know, review by appeal is problematic. Okay, so order setting a 366.26 hearing. Why is that unique? Nobody knows why that's unique. That's okay.
You only need
Is it an appealable order? No, it's a writable order. You gotta file a notice of intent, right? Okay, so there's a system in place. Actually, it's a rule of court that's in place. It says anytime the juvenile court clerk's office down here, through which all notices of intent and all notices of appeal move, okay, decides to reject for filing a notice of appeal or a notice of intent as late, it's late, they have to run it by the project administrator. California Appellate Project Los Angeles is the project administrator for the second district, okay? So that means Paul and I get these emails or facsimiles from Children's Court, the clerk's office down here, saying we're proposing to reject as late this notice of intent or this notice of appeal. All right, so the problem with the issue arising with the rejection of a notice of intent as late is the judicial officer's failure to comply with Rule 5.590B as in boy. What does that say? That says if the parent is present at the time the court sets the 366.26 hearing, the court, that means Judge Carlos Vasquez, must orally advise the parent of his or her opportunity to seek statutory writ relief. That's what the rule says. The minute orders that accompany the, you know, a notice of intent or a notice of appeal are what we as lawyers at CAP examine, looking for the, you know, either the parent get the a writ advisement. And we're frequently seeing that the court, that is the judge or the referee, is not giving that oral advisement. Now, this notice of intent might have been received a month after, or 2 months after the order setting the 2-6 hearing is made. But we cannot reject it or approve the rejection of it as untimely, as late, because the judge or the referee did not orally advise the parent who was present, hey, you want review? You've got 7 days to file a notice of intent. What does that mean to the writ attorneys in your firms? Like Rebecca and Steve and Melissa and Ellen Bacon, and forgive me if I'm missing any names. It means like, oh man, Of course, because responsibility for filing a statutory writ petition, by the way, I call these petitions statutory as opposed to traditional writ petitions, that are much, petitions for writ of mandate and or prohibition, or supersedious, et cetera. And so, okay, so the responsibility for these preparation of statutory writ petition is with the individual writ attorneys at your ladle firms, and you're getting probably bounced back to you very late and probably unmeritorious notices of intent that have to be processed, have to be filed. And so the point of this is you should be reminding the judge or the referee at the time that the 2-6 hearing is set, when your client is standing there, that Rule 5.590B requires a court to orally advise. Now you may think, well, gee, why do I want to tell the court to do anything right? Well, because frankly, you all have too gosh darn much work to do, and it's unnecessary work for your writ attorneys. It's just unnecessary. But anyway, I'll let you guys figure that out. But anyway, another really, really, really big problem here is, and dang it, I didn't cite the case here. But anyway, is writs, statutory writs that are prepared on behalf of the parent by the writ attorneys. You've got to start including ICWA era. Believe it or not, you've got to start including. What's ICWA? Indian Child Welfare Act. There's a CalICWA, shorthand. California has its own, like 224, 222, 223, 224 ICWA statute. And by the way, the rules of court implementing that statute are the subject of review because they're in conflict with the California statute and the federal statute. That's Abigail A. You'll see that in the big case summaries that I've handed out. So anyway, problem here is Division 3 of the 2nd District published an opinion this year. It's called Isaiah W. And in Isaiah W, and which is in your materials here, so all you got to do is go to your dandy table of contents. We'll show this to the audience out there in Lancaster, and you'll look down to Indian Child, or whatever the heck I have it under, Indian Children. Anyway, what did the 2nd District Division 3 do? It said, hey, we got an appeal from an order terminating parental rights here, and on this appeal, the parent is challenging the finding made by the juvenile court that the ICWA didn't apply. But when was it? But that finding was made at disposition, a year and a half earlier, or 2 years earlier, or 5 years earlier. Or it was made at the 6-month review hearing. In other words, it was not made within the 60-day window of review. As a general rule, you've got 60 days within which to file a notice of appeal. But remember, that general rule does not apply when? When doesn't that general rule apply? When you got a referee. You know why? You know why? No. But you will know. Because a referee's findings and orders, okay, are not final, are not immediately final. Judge Carlos Vasquez's orders or Judge Teresa Solden's orders are immediately final, okay? But referee Trinidad Costa's orders are not immediately final. They're not final until 10 days after service. Service ordinarily must be made by mail, okay, and is effective upon the mailing date. Only then, after that 10-day period passes, does the 60-day period pass. How do we know when the clerk served? Because the clerk has to prepare clerk certificate of mailing. Of course, however, if the parent is present in court, then we can, we don't, then personal service in the courtroom is sufficient, and, but still, 10 days, you got an extra 10 days. So, anyway, where the heck was I? Okay, so, I forget where I was. Right, no, I know I'm on info, but why did I want to say that? Right, so, okay. So Isaiah W. said, okay. So ordinarily, you have 60 days within which to file an appeal. Well, here's Division 3, looking at for the umpteenth time over the many years. I probably have a volume of, I don't know, at least about 150 cases just on ICWA law alone. Just on ICWA law alone. I mean, it's phenomenal. Anyway, so for 20 years, the Second District Court of Appeal has been entertaining challenges to an ICWA finding made at disposition 2 or 3 or 10 years earlier on appeal from an order terminating parental rights. Division 3 said, we can't take it anymore. We just can't do this anymore, and we're not going to do it anymore. So we're going to say that, hey, parent, on appeal from an order terminating parental rights, you want? No way in heck. You forfeited your opportunity to appeal the ICWA finding was when it was made, whether that was at disposition 2 years ago or at the 6-month review hearing. So this shifts the burden here to the writ attorneys at the ladle firms to start, you may not have any, believe me, it happens every day of the week. We don't have any argument to make on appeal from an order terminating parental rights except one, ICWA error. ICWA error. The notice was defective, or no notice was given at all, or the information that the parent provided was sufficient to trigger ICWA notice, or the tribe requested information and the social services agency didn't respond. So you may have a record prepared for your statutory writ petition to look at, and reunification services were denied, an aggravated sex abuse case. There's not any argument you can make on the merits challenging the denial of reunification services. But you've got to be looking out for ICWA error. You got to look at that advisement. You got to look at the information that the parent provided. You got to look at that. What questions did the court ask the parent at the detention hearing? And you might not get that detention hearing reporter's transcript, so you're going to have to augment to request that detention hearing transcript to find out what was asked and what the parent answered on the record. I'm happy to share with you voluminous materials on ICWA. There's, they're organized. So, but you just really got to start. The writ attorneys really have to look at this now. Just one more job to do. What a drag. I really am.
I just want to rewind just a tad bit to something that
Sure.
you said, where again the court had, let's say, contested to an E to an F to 2, and the court now is going to make, after contested hearing, they're going to stop reunification and set the 2-6.
Okay.
If our attorneys are listening, and the judge doesn't make the advisement to the client, the clerk doesn't give them their intent.
Right.
We're sitting on it.
Right.
All right, and we know we have to do something.
Right.
My question is, what obligation do we have at that point to inform the court? And is it in our client's interest at that point, if we hear that, and we're really contesting it?
Right.
Should we not say anything and allow that to go into the record? What's our obligation?
I don't think it's, Paul would like to answer that question, Paul DeQuatro.
Yeah, I don't think it's a good idea to sit on it, actually. I think it's a good idea to ask the court, would the court please advise the client of their obligation to file a notice of intent. And there's a lot of reason for that, because I think the client needs to know, first of all, that if they contest what's happening, they have an avenue to contest it.
I'm saying we inform our client, okay? But
Well-
we, what we're doing is embedding the court's error. We have an obligation to walk out of that courtroom, tell the client the court was wrong, here's your intent, sign it, we'll file it, then we talk to our writ attorney. What is our obligation in court to say that to the judge?
I think you should bring it up. Technically, you probably don't have a legal requirement, but that requires the appellate attorney a year from that point, or 2 years from that point, to do a prejudice assessment, and they're really not in the best position to do a prejudice assessment. And 9 times out of 10, there's not going to be anything that will flow from it, except perhaps